How bad is a second DUI in Indiana? A second DUI in Indiana is seen as much more serious than a person's first DUI. And it doesn't matter if it's called DUI, DWI, OVWI, or anything else. It's all the same. In Indiana, they're legally called OVWI, operating a vehicle while intoxicated, but it does not matter what you call it. What matters is a second DUI arrest is much more serious than the first one. Why is that? Well, it's a matter of perspective. Many judges and prosecutors understand that a DUI is not like a normal crime. Most normal crimes require a mens rea, which is a bad thought. For example, I'm at a bar and someone's screaming, "Free bird!" at the live band. Someone else goes to punch that person that's demanding Free Bird be played. The person that threw the punch wanted to throw a punch. They meant and intended that the person be hit by their fist. A DUI doesn't have any of that. 99.9% of my clients never say, "I can't wait to drive drunk tonight." In fact, some of them are so close to the legal limit. If they'd waited 1 hour or more before driving, they likely would not have been arrested when pulled over. DUI is not a normal crime. There is not an intent element. Many judges and prosecutors understand that a DUI arrest doesn't automatically make a person bad. But the problem is, when people get a second DUI arrest, prosecutors and judges become much less understanding. In fact, many of them have the opinion that the defendant is either, number one, simply not getting it, or number two, has a drinking problem, or number three, maybe a little bit of both. What are the penalties of a second DUI conviction? First off, if the second DUI is within 7 years of the first, then the new charge will be a level 6 felony with a maximum punishment of 2.5 years in jail. If your second DUI is more than 7 years from your first, well then it's not going to be as bad because it will only be a misdemeanor, but it's still terrible. It's like someone saying, "Well, I'm just a little bit on fire." It's still bad. You're on fire. Everyone can agree felonies are absolutely no fun. You can't own a gun with a felony. Many jobs actively discriminate against people with felonies. Many professional licenses are lost because of felony conviction. For a second DUI conviction, there's also mandatory jail time. The minimum sentence is 5 actual days in jail or 240 hours of community service work. And it does not matter if the prior DUI was 2 weeks ago or 25 years ago. If a person has a conviction for a DUI or any similar type of crime, if they call it something different in different states, they will automatically be subject to the minimum. Sometimes clients call and say, "Mark, 5 days in jail, that's it? Woo! I thought it was going to be much more worse than that." It's 5 days is the minimum. That's mean the floor. You have to at least do that. Most judges and prosecutors want way more than the minimum. With the second time DUI, significant jail time, home detention, and even work release are on the table. And now let's talk about the fun part of license suspension. A license suspension is much more worse for a second time DUI. Why? Well, let's start at the beginning. If it's not a felony, then the minimum license suspension is 1 full year. If the second DUI is a felony, then the license suspension ranges from the minimum of 1 year to a maximum of 2.5 years. And it's the judge's choice as to whether or not to allow that person to drive for life's necessities during the suspension period. And all the time we've talked about doesn't even take into account if there's a refusal. If there's a refusal, the refusal suspension is 2 years. This is in addition to the DUI suspension. And with the refusal suspension, there's no easy way to get a person driving, and it's not easy to get rid of the refusal. But it is possible. It's not like, don't abandon all hope. It's dealing with the refusal is possible with the right approach. The bottom line, the penalties for a second DUI are much worse than for someone's first DUI. And the punishments vary county by county, and in some cases, even between judges within the same county. It can even depend on the prosecutor you get who's assigned to the specific court. It varies all across the state and even county within county. So you can't control where you are charged. You can't control which prosecutor will be handling your case. You can't control which courtroom you'll be assigned to. But you can choose to hire the best attorney possible. And a person who is arrested for a second DUI can start doing things now that will help improve the odds that he or she receives the minimum type punishment possible. Questions? Give me a call, 317-632-3642. I love talking about Indiana criminal law. In fact, I'll do it all day. But most importantly, remember to always plead the fifth.